Hello everyone, my name is Martin Willemse. I am a partner at the firm of Samfiru and Tumarkin LLP and the Western Canada practice leader for disability issues. So this is the live disability law Q&A. Before I start, we're welcoming everybody's questions through social media platforms. We'll answer your questions live. You can go and ask your questions at Disability Insurance Questions Now. Go to disabilityrights.ca to get more information. We have offices throughout, in BC, Alberta, and Ontario, and we practice throughout Canada, other than in Quebec and the territories. So, questions regarding disability law, please send them to us, and I'll answer them as they come through. We'll start off with some questions regarding the difference between own occupation versus own job. This is something that comes up routinely because many people do go on disability as a result of workplace bullying and harassment. When you complete the forms for the disability application, so you apply for LTD, you have to complete a form which is normally called an employee statement. You would note why it is that you're unable to work. Some people may say if it is a workplace harassment issue, if there's a little box that can be ticked and is this due to a workplace incident, people would tick yes. The moment you do that, the insurance company may be looking at, are you disabled from performing the duties of your own occupation? Or is this something that is specific to the workplace, meaning your own job? And claims get denied routinely on that basis. Most disability policies, if not all, group policies will provide that in order to qualify for long-term disability benefits, you have to show that you are totally disabled within the meaning of the policy. Total disability has its own definition, and it will be that you must be unable, due to an illness or a condition or an injury, to perform the essential duties of your own occupation, not your own job, your own occupation. Go back to the example that I was using. I've seen this many times before. Somebody who works in a bank, they may have a new supervisor. They feel that the supervisor is picking on them, is being rude to them, is ridiculing them in front of their colleagues, and they develop an adjustment disorder or depression or anxiety, whichever one may be. They complete the forms and tell the insurance company, because they're trying to be transparent and forthright and honest, that this is solely as a result of workplace bullying and harassment. Two things to be said about that. The first one is, if that is the case, if you do have a recognized disability, mental health illness, that has resulted solely as a result of workplace bullying and harassment, you may be able to submit a claim to WorkSafe, a WCB claim. The reason why that is relevant is because insurance companies would push people to apply for WCB benefits because the policy allows them to deduct such benefits from the benefit amount. The other thing is they may deny the claim because they may say this is a workplace incident. It is not a disability, which of course makes it more problematic because the fact that you have been diagnosed with this means that you have to be treated for it first before you would be in a position to go back to work. However, if it is the position that you feel, just put me in a different location, or if I could do this job for a different employer, then you may not qualify for disability benefits, because then it means you may just be disabled from performing the duties of your own job versus your own occupation. So if your claim is denied on that basis, please reach out to us and we can give you further information as to how to approach it and what your options are, which may include pursuing a legal claim or some other options as well. But remember, you need your doctor's support. The focus has to be that you should be treated first before you would be able to return to the workplace in any capacity. Because if you're already diagnosed with a mental health illness, be it major depression, just because you're not going back to the place where you were bullied and harassed doesn't mean that that necessarily is just going to resolve itself. You may still need further treatment. So these cases are denied routinely. And I speak to people about this and my colleagues as well on a weekly basis as to what their options are. I've got a question from Christina Shrilevan. My sister has recently been diagnosed with fibromyalgia but is struggling to get LTD. What is the best way to handle a claim for fibro and deal with a denial? This is a good question, and it's a question that comes up very regularly. Fibromyalgia is one of those conditions that is deemed to be what is called an invisible illness or a subjective condition. Invisible, I think, is somewhat offensive. Having said that, that's how it is described quite often. Fibromyalgia and the knowledge surrounding it has come a long way. There were doctors in the past, and I think there may still be, but they're fewer now, that view fibromyalgia as not something that is real. And you see that sometimes reflected by insurance companies as well, and to some extent, some judges too. Having said that, it is a real condition. There's medical literature to support that. So when you have a condition like that, the insurance companies often look at what are your symptoms, because they're based on subjective complaints to your doctor. If there were to be a denial based on that, number one, I would say reach out to us and we could discuss our options with her and explain how to approach this. You may want at the other end, how can you get it approved? You want your doctor's support. You want your doctor to detail what the restrictions and limitations are, what objective observations the doctor has made when seeing your sister while doing clinical examinations, what medications have been tried, be it Cymbalta or some other medication, how your sister has responded to that, what are her occupational duties, and how do these symptoms, these restrictions and limitations impact your sister's capacity or ability to perform those duties. Remember, a disability claim is very focused on functional impairment, more so than the diagnosis itself. Of course, the diagnosis is important, but it's why can the person not function in their occupation? So with fibromyalgia, it may be that she has widespread diffuse pain. It may be brain fog. It may be issues with concentration, focus, memory, poor sleep. Fibromyalgia often is accompanied by IBS and some other conditions. So go to the doctor, get a letter to detail what these restrictions and limitations are, what steps have been taken to further investigate it, what medications have been tried. And if they're still not approving the claim, really, you're dealing with an insurance company who does, if you did do an appeal, it's the same entity who denied the claim that is reviewing the claim. So it may be worthwhile to just have a discussion with the lawyer to explore what your options are. But these cases, as I say, are routinely denied because it is based on self-report. So I hope that was helpful. And again, as you can see on the screen, to contact us to find out more, go to disabilityrights.ca. We've got an email question from Paulina. Is there a time frame for making a claim? What if you had an injury a few years ago, but it's only become a serious problem recently? These are good questions. There is a timeline to submit a claim. There are two timelines. The one is called notice of claim, and the other one is called proof of claim. Let me backtrack. Disability claims are based on contracts, which are the policies. The contracts has rights and obligations and provisions. So in terms of the contract, it will advise you how to submit a claim, when to submit a claim. And it may be that you have to provide notice of claim within 30 days of the disability and proof of claim within 90 days of the disability. It depends on every contract because they're all different. But for the most part, what I've just said, the 30, 90-day thing would somewhat be accurate. Others may say that it has to be done 30 days after the elimination period has expired. Now, the elimination period may be the short-term time frame, which often is 120 days. But again, it depends on the timing of the policy or the wording of the policy. If you have an injury that happened a number of years ago, it's different than when you have an injury under a tort claim where you have to, I suppose, file a claim within a certain period of time. With an injury that happened a few years ago and you now submit a claim because the injury has become so bad, I suppose, that it is now disabling, that is something that you should look at, because if your condition is disabling only now, the time frame starts to run, in my mind, when the disability arises. So if that is the case, the disability arises, the time frame should run from that date. If again there is a denial based on contract, please reach out to us. If they're saying you are late in applying for the claim or you're late in submitting a proof of claim, please reach out to us and we can discuss what your options are. We've got a question from Bill on YouTube. I've been on cutoff from my short-term disability, but still have to be off for a while longer. Is there anything I can do about this? If you have been denied short-term disability, sorry, I'm misunderstanding this question. You have been on short-term disability and now you are becoming, and your disability is ongoing, but you've been cut off because they paid you for a period of time. You have options. The same would be, it depends on who the insurer is, because sometimes short-term disability claims are self-insured. In other words, they're paid by the employer but adjudicated by an insurer. So you may see all the correspondence coming from the insurance company, but the actual payor is the employer. Same principles would apply. If you are denied and you remain disabled, you want to get a letter from your doctor detailing what your restrictions and limitations are, why you remain disabled from working, and if the doctor doesn't support you, which really shouldn't be the case, I'm sure, try and get letters from every treatment provider that you have. And also, as with every question I say, reach out to us and we discuss your options with you further. There is a problem here sometimes when somebody has short-term disability benefits and they are denied during the, say, short-term is 4 months, say they're denied at the 3-month mark but remain disabled. At some point, they're going to transition into long-term disability if they do have long-term disability coverage. And that may mean that the long-term disability benefit is insured and paid by a different insurance company. You want to make sure that you still apply. Even if you've been denied for the short term, you still want to apply for long term, going back to the very first question, because of those notice provisions. If it is the same insurance company who denied you short term, still tell them, I want to apply for LTD. And if they say to you, no, we're not going to let you do that, have them put that in writing, because if you do pursue a legal claim later on, you don't want the insurance company to tell you that you never applied. If they're the ones preventing you from doing so, the problem lies with them, not with you. But you want to make sure that things are clear at your end and you do abide by the notice provisions. So again, if you're denied short term, reach out to us, but also make sure that you do apply for long term if your disability is ongoing, especially if it is insured by a different insurance company. And the way that you do that is contact your human resources at your place of work and make sure that they give you the application forms. Okay, question from on Reddit from APO, if I see that correctly. I was hit by a truck while riding my bike. I will likely have permanent physical limitations and have suffered a TBI, meaning traumatic brain injury. I'm not sure where to start with filing a claim for disability and injury. How do I start this process? Do you have any suggestions to help? You were hit by a truck while riding a bike. If you have coverage through your employer, so I'm going to assume here that you are employed. If you have coverage through your employer, make sure that you apply or contact your employer to provide you with the disability forms, the disability application. There are three forms. The first one is the employee statement, which is something you will complete. The second one is called an attending physician statement, which is something that your doctor will complete. And the third one is the plan sponsor statement, which is something that the employer should complete. Make sure, as with every other question that I've answered this morning, that you don't miss those application deadlines. If you do, still apply. And if they deny, reach out to us. But you must make sure that you get those forms completed, submit them to the insurance company. If you do not have coverage through your employer, you may want to look into provincial or federal plans that may provide some disability coverage. If you did work at some point in your life and you did make sufficient contributions to CPP, for example, you can apply to them and see whether your claim will be approved. Following an injury, I suppose it depends on in which province you are. If this was due to the negligence of and it sounds like it was, a truck driver, it depends on what province you are. If there are no fault regulations, hopefully not. But if there are claims, if there is an opportunity to submit a claim, then you do want to reach out to us as well and just have a discussion as to whether there is a claim to pursue in terms of the negligence claim, not the disability claim. The disability claim itself, make sure that if you do have coverage, you get the information from your employer and submit it as soon as possible. And if there are issues with that, by all means, reach out to us. Question from Carla on YouTube. I've been off on STD, short-term disability, but my doctor has said I'm going to need a longer recovery time. How do I transition to long-term coverage? Well, this is very similar to the question that I just answered from somebody else. If you're still not short-term and your doctor says you're going to need a longer period of time to recover, which means that you remain disabled from working, you want to be in touch with the insurance company who's paying your short-term and tell them, look, this is what my doctor says. Maybe get a letter from the doctor to support that as well. Reach out to the employer and make sure that you can apply for long-term disability coverage. In other words, let them give you the application forms. If it is the same disability insurer on short-term as it is on long-term, they'll continue to adjudicate your claim and then probably advise you whether your claim is such that you do qualify for long-term. Again, if they deny your claim, saying that they disagree, we've got a bunch of cases like that where we are contacted by people and we actually are representing people with similar situations. If that does happen, if they do deny your claim, you have options, and that's what we do. We assist people with denied disability claims. We provide free consultations. So if you want to give us a phone call, discuss your situation and your circumstances with us, we can review the policy, the denial letter, your medical information, and discuss with you what your options are so that you can make an informed opinion as to how to proceed. Don't just do it by yourself. Reach out to us and get some information. Again, you can go to, as you see on the screen, go to disabilityrights.ca to find out more. If you are, as I said, still in the short-term phase and is going to transition, make sure that you apply to the other insurance company if it is insured by a different insurer, and make sure that you have your doctor's support. Continue to see your doctor on a very regular basis, especially during this transitional phase, so that the doctor can detail what are the restrictions and limitations that continue to prevent you from returning to work. We have a question on Reddit from SC. My father recently passed and I will be receiving some inheritance from his estate. Why do I have to declare with my LTD insurance? Will this impact my payments? That's a very good question. And, again, it's something that we see regularly, not specific to inheritance, but sources of other income or other money coming to somebody. Disability policies have what is called offsets. Some of them may be direct offsets and others may be indirect offsets. Offsets will refer to something that is deductible from a disability benefit. The direct ones almost invariably will be CPP disability benefits, WorkSafe benefits, and maybe some other benefits that you could get through the government. Indirect ones may be some other pension plan payments that you may receive if you're getting children benefits through CPP, or severance. Not all of them, it all depends on what the policy says. But in my mind, it's all related to income replacement. So what benefits are you getting through income? Receiving inheritance from the passing of your father, and my condolences on that. Receiving an inheritance, I don't see that as income. It really depends on the wording of the policy, but I will say this, I've never seen a policy where inheritance money is deemed to be an offset. So I don't deem that to be something that would affect your disability claim, unless it would be, for example, where the insurance company would find out and say, oh, well, we think you've got a lot of money, you're not really motivated to return to it, which is an entirely different issue. But is it an offset under the policy? I'll say this with a caveat, it depends on the wording of the policy, but I don't believe inheritance is an offset. We have an email question from Veronica. I've been on LTD for the last 2 years. I've been told that I do not fit the definitions of the policy to continue receiving payments. I'm not sure what that means. My doctor has said that my condition is quite serious and I likely won't be able to return to work for several years. What are my options? That's the typical question that one would get with a disability insurance. If you don't work with this and you've never dealt with an insurance company, I'm not surprised that people are confused by the wording, we do not deem you to be totally disabled. That phrase, totally, is confusing. Even with doctors. I've had discussions with many doctors. I've spoken at conferences where this comes up every now and again. What does total disability mean? Remember, this is all based on contract. The contract has definitions in it. Total disability, as misleading as that phrase may be, means that you must have an illness or a condition that prevents you from performing the essential duties or the regular duties of your own occupation. So that's for the first own occupation phase, which is normally 2 years. Then the definition changes to the extent that you must be unable to perform the duties of any other occupation based on your transferable skill sets. But let's just go back to the first definition, the own occupation one. Total disability, if you were to look at it outside of a contract, it sounds like you are totally disabled. And that's what many doctors think, and that's what many people outside of the sphere thinks, because the word total means you cannot do anything. You may be bedbound. You cannot feed yourself. You cannot dress yourself. You cannot do anything. That's what total disability sounds like. But in the context of a disability policy that you may have purchased or that you have through your employer, it doesn't mean that. You can still perform the activities of daily living. The question is, are you unable to perform the duties of your occupation? For example, if somebody has a bad back and they have a very labor-intensive job, they cannot, for example, let's say they are picking up the garbage. That's what their job is. They have to get out, pick up the bins, throw it outside, move around, climb, jump, walk around, pick things up, bend, lift, carry. But you have a bad back. Are you disabled from performing your duties? It depends on how severe it is. But if it is that, yes. Does it mean that you could still feed yourself? You can still dress yourself. You may still be able to unpack the dishwasher. So those are relevant questions. But the relevant portion here is, are you unable to perform the duties of your occupation? So you're totally disabled if that is the answer to that is yes. But outside of the contract, it may not be understood that way. So again, if your doctor supports that you cannot work, your doctor says that it is serious, you want to have your doctor write a letter and support that. Focus on what the restrictions and limitations are, detail what your occupational duties are, and then correlate the two to see whether, based on those restrictions and limitations, can you perform those duties? And if the insurance company says, no, we disagree, and your doctor says, but I disagree with the insurer, you cannot work, and you disagree with the insurer, that's when you contact us, because we can discuss your options and very possibly assist you through through a legal claim. This is from Christina. Why do insurance companies suggest you appeal your claim if they aren't likely to change their minds? It's a good question. Insurance companies will say to you, appeal the claim. Remember why? Because they may not want to be in a legal claim. I'll speak to you about what a legal claim means. A legal claim gives you leverage, right? Think about when you submit an appeal. You're writing a letter, your doctor is writing a letter. I'm not saying don't do it. I'm not saying that is not an option. But in my experience, not many of them are successful, at least the ones that contact me and say they've already tried this process. Remember, if you fail with an appeal, you can still pursue a legal claim if there are no other restrictions preventing you from doing that. But why do they ask you to do an appeal? Why do they submit that? Because they don't necessarily want you to pursue a legal claim. A legal claim gives you leverage. With an appeal, it literally is you asking, please, insurance company, will you pay me my benefits? You have nothing on them. There is no leverage. But when they're in a legal claim, they don't want to be in that. Even when they still disagree with your position, they don't want to be in that, because ultimately it ends up in front of a judge potentially, who then makes that decision. And then it's not to the insurance company. So having a legal claim gives you leverage, and you have somebody advocating for you. You have a lawyer who has dealt with insurance companies on many occasions and knows what the policies say, knows what the medical evidence is that is required, and allows you to focus on your treatment, where the lawyer then deals with the insurance company. And you don't have to work with them anymore. You don't have to speak to them anymore. It all goes through the lawyer. That's maybe one of the reasons why they don't want that to do that. But remember, when you appeal, it's not as if you went to the provincial court and now you're going to or rather, if you went to the Supreme Court of your province and then go to the Court of Appeal. These are two entirely different entities. The insurance company who denied your claim is the exact same entity who is now reviewing the appeal. So consider that. But if you want to discuss that further, by all means, contact us. And as I said, we can provide you with a free legal consultation and discuss with you what your options are, so you can make a decision as to what makes sense to you. It may be that you want to do the appeal, or it may be that you just don't want to do that either. You want to pursue a legal claim. We discuss options and allow people to choose what makes sense for them. As you can see on the screen again, go to disabilityrights.ca for more information. We have a question on YouTube from Serena. How long do you have to be off from work before you can claim LTD? Look at your policy. So there's something called an elimination period. Another word for it may be qualifying period, and another one may be the waiting period. The elimination period is the timeline as to how long you have to be off work before long-term disability coverage will kick in. If you do have short-term disability coverage through your employer, that would be the waiting period. But if you do not have short-term disability coverage, and there are people out there who don't through the employer, that is called a waiting period, the elimination period. It may be 3 months or 4 months. When that ends, long-term disability coverage or benefit payments should kick in if the insurance company agrees that you're disabled. So look at your policy, make sure what coverages you do have. If you do have short-term, it may be that the waiting period is 7 days or even 3 days. Depends on the language of the policy. With long-term disability benefits, I've seen waiting periods as long as a year, but then it means that the person has short-term disability coverage for that year. Generally, it's about 4 months because it's somewhat the same time frame as what you would get if you were to apply for medical employment insurance. So look at the policy and make sure that you have, if you do not have short-term, because you want to make sure that you apply to both short-term, and if the time comes, you should also be applying for long-term. And again, as with every question, if they do deny your claim, contact us. If you have more questions about this, contact us. We, as I've said before, we review your policy with you if you do have a copy of the policy. And if you've got those specific questions, we can phrase, at least point to where it is so that you have information. Information is key. Information is power, right? It gives you some comfort as to know how to navigate this process. Because for many people, it is the very first time that they're dealing with this, and they don't understand what does elimination period mean, what does waiting period mean, what is the definition of total disability, why does the insurance company say I don't have enough evidence? Because that's something that comes up all the time. Why is it that the claim is denied when my doctor says I cannot work? We're running out of time, but I'll say this quickly. Remember what I said, a diagnosis is important. The most important thing is functional impairment. So if your doctor says and agrees, gives you your diagnosis of this person has depression, they cannot work, submits that to the insurance company, you may be faced with a denial because the insurance company will say, well, we don't have enough medical evidence. Depression is another thing that is deemed to be based on self-report. So you want to get your doctor detailing what are your restrictions and limitations. Remember what I said about functional impairment? Depression, for example, poor focus, poor concentration, poor memory, inability to multitask, inability to comprehend new information, low energy, profound fatigue, low motivation, issues with sleep, social isolation. Put all of that in context as to why it is that you cannot perform the duties of your specific occupation, not your job, your occupation. Because if that's the approach and if that's the information that you submit to the insurance company with the initial application and they still deny your claim, contact us. We'll help you deal with that. So that brings me to the end of today's session. Thank you for joining. Find out if you have a claim. Oh, there it is. We've got a new app available called pocketdisabilitylawyer.ca. Please go out and look at that to see whether you have a claim. It has various options. It's brand new. We encourage people to look at this and it'll guide you through various drop-down lists. Our next Q&A session is an employment law Q&A, and that is on Wednesday, which is tomorrow, September the 6th, at 1 p.m. Eastern Standard Time with my partner, Leo Samfiru. So if you've got employment questions, follow that tomorrow. Thank you for joining us. And again, visit disabilityrights.ca to discover what your rights are. And I welcome the questions for our next session. I wish everybody a good day. Thank you.